for those of you who may not be familiar with him. Ben Glassman is a native Cincinnatian, Rice undergrad, Harvard Law. He clerked for both United States District Judge Susan J. DeLotte as well as Sixth Circuit Judge Gilman. By count from reviewing his resume, he is admitted to over half of the U.S. Circuit Courts, I believe, as well as an admittee to the United States Supreme Court. He spent 10 years of his career following his clerkships working for the U.S. Attorney's Office for the Southern District of Ohio as a federal prosecutor, and then went on to lead that office from 2016 to 2019. He is now a partner at Squire Patton Boggs, and one of the many feathers in his cap is to be a fairly regular contributor to the Sixth Circuit appellate blog that Squires sponsors and hosts. I myself am an avid reader of that blog. For those of us that are practicing in federal court in the Southern District, I think it's an invaluable resource. And if you have not subscribed to receive it or haven't checked it out, it covers case updates and statistics and all matter of goings on in the circuit that are really helpful to local or even national practitioners, but those with a particular interest in what's going on the circuit. So I would commend it to you if you haven't signed up for it. It just so happens that as a regular reader of that blog, I noticed in May of 2023, an article that was posted by Ben Glassman entitled "The Virtues of Restraint in Federal Appellate Brief Writing." And I thought to myself, that is a perfect topic for a professionalism committee Take 10 presentation. It combines insights from someone who is a accomplished appellate lawyer and practitioner in the circuit, as well as trial court advocate, and overlaps obviously with our interest in professionalism and how that can enhance your practice in the everyday. So without further ado, I want to thank Ben for taking time out of his schedule to be with us today, and I'm very much looking forward to his program. I will take myself off camera and we'll let Ben take it away. Thank you.
Thanks so much to Laura for that super kind introduction. And thank you to Laura and to Grace for inviting me to speak today. Thanks to the Cincinnati Bar Association for affording me the opportunity to talk. And thanks to all of you for attending today's presentation and listening to me talk for just a few minutes about something that I think is pretty important. My topic today is civility in legal practice. And I'm going to be talking about it principally in terms of written advocacy, but that's just one example of how this comes into play. My guess is that since you're on this call, you all already think that civility is important. And my goal in the next few minutes is to explain why it may be even more important than we all think on an everyday basis. Now, of course, I am hardly the first person to talk about civility, hardly the first talk to a bar association about civility. If you look at the local rules for the United States District Court for the Southern District of Ohio, before you even get to the first rule, there's an introductory statement on civility that's attributed to all of the federal judges of the court. And it says, among other things, lawyers committed to professionalism must do more than merely avoid sanctions. They must acknowledge in their behavior that common courtesy, respect, and personal integrity play an essential role in the administration of justice. And then these judges in the introductory statement on civility go on to offer a number of examples, or really more like reasons in support of the idea of civility in legal practice in our courts. The first one is common courtesy. Just something that human beings expect every day. And the judges write that involvement in the legal system does not diminish the desirability of such conduct. Their second reason is respect for the profession, where they write, among other things, that, basically lawyers already have such a bad reputation, and disrespectful or obstructionist behavior reinforces the public's negative perception of the legal profession, which obviously we want to avoid. Their third reason is respect for the legal system, and they opine that inappropriate behavior brings disrespect upon the legal system as a whole. And yet, in my experience, written advocacy in our courts tends too often to include extreme language or to impugn the motivations of our adversaries, or just to be snarky. If you've ever, just to give you an example about what I'm talking about, if you've ever read a brief, maybe written a brief, that repeats an opponent's argument, period, and then just says ridiculous, period, or that argument is absurd, period. I don't actually even need to give you a lot of examples from my own experience, because the United States Court of Appeals for the Sixth Circuit has an opinion that sets out some of them. And here I'm looking at Big Dipper Entertainment LLC versus City of Warren, a 2011 opinion, where the opinion says, Big Dipper criticizes the district court's finding in notably harsh terms, asserting that the district court made no pretense of applying the proper standard, that the court's analysis was cursory, that the court chose to disregard the voluminous and detailed analysis of its expert. Big Dipper similarly accuses opposing counsel of making egregious misstatements to this court, etc. And with respect to snark, Laura mentioned that I have a post on the Sixth Circuit Appellate blog about restraint in federal appellate brief writing from May of 2023. That very same month, a very prominent Supreme Court advocacy shop submitted a supplemental brief at the Supreme Court, May 2023, which says, among other things, nearly 1 year after the court invited her views, the Solicitor General has delivered what can only be described as a hot mess of a brief. Why? Why do we have this kind of writing in our advocacy? I think we should acknowledge that there are some incentives for this kind of style. First off, we as lawyers are people, and we're very invested in our arguments and our cases. And when you read something that comes across to you from an opponent as ridiculous, I think it's pretty natural to want to say so. But more than us being people, our clients are people. And even when our clients aren't people because they're organizations, those organizations are run by people. And those people often have very strong feelings about the dispute that's the subject of the litigation, or about the conduct of the opposing party, or perhaps they've hired a lawyer to quote unquote fight for them. And I will say that I see this style more in private practice than in government practice, and that might have something to do with clients. I think there's even an aspect of our culture that just prizes fighting for its own sake. That seems to have gotten more prevalent in the last 5 to 10 years. Even federal judicial opinions, unfortunately, are snarkier now than they were when I started practicing over 20 years ago. I think one of the reasons for that, from a private practice client perspective, is that when you see extreme language, you can see what is perceived as a lawyer striking a hard blow for a side, even if you're not deep in the weeds. But does that kind of style actually work? Well, the Sixth Circuit has said that it does not work, and have given a couple of additional reasons as to why. And here I'm looking at a case called Bennett v. State Farm Mutual Automobile Insurance Company, a 2013 published opinion, where the court says, there are good reasons not to call an opponent's argument ridiculous, which is what State Farm calls Barbara Bennett's principal argument here. The reasons include civility, the near certainty that overstatement will only push the reader away, especially when, as here, the hyperbole begins on page 1 of the brief, and that even when the record supports such an extreme modifier, the better practice is usually to lay out the facts and let the court reach its own conclusions. So these are arguments that pertain to a judicial reader of advocacy, what's likely to work for that reader. But what struck me about Bennett and Big Dipper is what comes next in those cases. So immediately after what I just read in Bennett, the court says, but here the biggest reason is more simple. The argument that State Farm derides as ridiculous is instead correct. And then similarly, Big Dipper, where I just read all of the examples of the extreme language, the court says, in any event, Big Dipper cannot back up its charges here. I think that there's a reason for this. I think there's a reason that when courts talk about extreme language or snarky language or impugning motives, it often ends up that the party making those kinds of arguments loses. And I think that's because this kind of rhetoric is an analytical crutch. So here I want to offer some arguments about the lawyer as a writer as opposed to the judge as a reader. Most importantly is that actually explaining step by step why you should win so that the logic and the law is inescapable. That's hard. That's hard to do. And name calling or characterizing an argument as ridiculous, in my experience, is usually a substitute for doing that kind of hard work. Same thing with impugning motives. It's much easier to just say that someone is disingenuous than to actually try to grapple with how an opposing argument could actually work. And I might add that understanding the best form of an argument, whether the adversaries made it in the best form or not, is usually a prerequisite for generating the most effective rebuttal. And even if this kind of style isn't a crutch in one's particular case, at most you're just taking up extra space. Why would a judicial decider care what the advocate personally thinks about an argument? What matters is whether the argument is right or wrong. Now, when I've tried to make some of these arguments with colleagues, I sometimes get the counter argument of, yeah, but the judge is right like that. So doesn't that mean that we should too? And the answer to that is no. It doesn't matter whether the judges write snarky opinions or not. For one thing, they have the luxury of deciding the case. They don't have to be themselves persuaded in the same way that advocates have to persuade. Now, I do think that they should care for the last reason that I want to bring up. And that is that, in my view, civility doesn't just help preserve the professionalism of legal practice. In my mind, it supports the design of the American legal system itself. Why is that? It's because cases are supposed to be decided on the facts and the law. So I had asked earlier, why would a judicial decider care what an advocate thinks? A judicial decider not only wouldn't care, but shouldn't care, because they're supposed to be deciding the case on the facts and the law. And to the extent that litigation is about anything other than the facts and the law, that, in my opinion, undermines the integrity of the rule of law, at least in one small respect. And so I think that if we can all commit to refraining from using extreme language, from impugning motivations, and from snark in our written advocacy, number one, we will produce better work, stronger briefs on the merits, and be better advocates. And number two, we will thereby support the actual concept of the rule of law in our everyday practice. And again, I want to thank the CBA for giving me the opportunity to speak.